Hello, my name is Michael Tesaro and I've prepared this video case note entitled Getting Lost in Narnia, where I'll be looking at the ACCC case against Google. And the reason I call it Getting Lost in Narnia is for two reasons. Firstly, the project which brought about these particular changes was codenamed Narnia by Google. But also I think the ACCC lost its way a bit in trying to run this case, and as a result it's a very confusing sort of presentation of the case and probably contributes to the way or the reason they lost the particular case. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my practice Tesaro Legal Consulting for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked with the ACCC for 15 years in a variety of roles, including as a Director of Enforcement. Outline of the presentation pretty straightforward. Look at the background facts, the decision, and discuss the implications of the case. Now, the background to the case relates to some conduct by Google between 2016 and 2018, which was codenamed Narnia 2.0, NS, N20, or simply Narnia. And it was really to introduce a number of changes to the settings in their Google accounts. The first was that they wanted to combine or associate personal information from account holders with the activity on third-party websites and third-party apps, as well as combining it with activity on Google services. And they wanted to allow that combined or associated information to generate new advertising for both Google partner websites, Google partner apps, and also to deliver additional advertising to account holders on both Google services and Google partner websites and Google partner apps. So allow the association of information to generate more advertising for consumers and to deliver that, and as a result generate a lot more advertising revenue. Now, the ACCC's case was that it believed that the way Google notified its account holders of these changes was inadequate, that they had failed to spell out what was actually happening, and furthermore they made a number of changes to the privacy policy which weren't spelled out. So there was two breaches. The first was a notification breach, and the ACCC alleged that effectively Google had told consumers that it was only seeking to do a couple of things, that you turn on this new feature, and that as a consequence more information would be visible in account holders' accounts. It would be easier for account holders to review that information and to control that information. And secondly, that Google would be using this information to make advertisements more relevant to account holders. So it's very beneficial for account holders when the ACCC believed that this wasn't correct. This wasn't really what was going on. The second representation was called the explicit consent representation, and I think there's a lot of overlap between the notification representation and the explicit consent representation. But here was saying that in relation to the changes to Google's privacy policy, Google had not made it clear what they were doing in terms of making the changes, and they had actually reduced the rights of consumers by changing the privacy policy. And this is in the context where they said they wouldn't reduce the rights of account holders. Now, the first was to delete the double-click statement, and this arises from a commitment given by Google when they acquired DoubleClick not to use DoubleClick information and associate it with their own information. And the only way they could do this association of DoubleClick cookie information with their own information was if they obtained account holders' explicit consent to that usage. The second thing was that the ACCC alleged that Google had not obtained the explicit consent of account holders, that they would be combining information that they collected, personal information about consumers, with third-party websites, third-party apps, and that by turning on the new features they were actually authorizing that conduct. So those were the allegations which ACCC claimed weren't made clear to consumers. Now, the evidence in the case was interesting. It was really based on expert evidence and internal documents, and the ACCC had an expert from the University of New South Wales called Associate Professor Paisan Lenestor, She was from the University of New South Wales, and then Professor Liss from the University of Chicago. And these experts were, I think, behavioural economists who spoke about the way that consumers looked at various websites and information on online sites, and the way they would understand them, interpret them, the way people, the level of focus and attention given to such announcements, and a number of internal documents. The key issue here was there was no consumer evidence from account holders as to how they understood the various notifications, and I think that's a key issue which I'll return to later on. Now, the background to the case, there was a couple of settings which are important. The first was a WWA setting, which was a key setting in the Google location data case, which the ACCC won last few years. And effectively, the WAA setting allows Google to store a vast amount of information about account holders. As you can see, it allows them to gather information from Google Search, Google Maps, Google Play, and so on. So it creates a huge repository of information. The second was the SWAA setting, which is something the consumer has to turn on, which allows or permits Google to associate all the information that obtains through the WAA setting with other applications and Chrome and various things. So that's really where a lot of the advertising sort of revenue comes from that association of information. And the Chrome Sync setting, which is a setting which consumers have to turn on, which allows effectively the browsing history from Chrome of the consumer to be associated with other Google information. So again, a way to generate targeted advertising. Now, the fundamental change being introduced by Narnia 2.0 was to obtain the explicit consent of account holders to, I guess, merge these two bits of information together. The personal information which Google collects through those particular programs with other activity on Google partner websites and Google partner apps. Now, the ACCC made a number of submissions as to the harms generated or caused by this conduct, and they're set out there. Firstly, is they claimed that the notification did not make it clear that Google was proposing to associate the personal information of account holders with this activity on third-party websites and third-party apps. Also, they claimed that it was being presented, these changes, as a benefit for consumers, whereas in actual fact it wasn't beneficial for them. It was going to result in them getting further targeted advertisements, and there were obviously a lot of benefits for Google in terms of generating additional advertising revenue. Also, the language used, the ACCC alleges, was such that it would have led consumers to believe that Google was not actually creating any new information, it was simply using existing information, but in actual fact it was collecting and combining additional information and data as a result of the changes. Another allegation that there was a representation about benefits for the consumer. In the statement of claim, there was an allegation that Google framed the changes as something that would improve Google services and the ads delivered by Google. So it was going to provide benefits to the consumer, and the ACCC believed that wasn't correct. And finally, that the notification did not inform account holders that there was going to be a change to Google's privacy policy. Now, the judge looked at the reason for the Project Narnia, and they stemmed from that previous commitment by Google in relation to DoubleClick not to move the information from DoubleClick and associate it with their own personal information in order to generate obviously further targeted advertising unless they receive the user's explicit consent. So as the judge says there, Narnia 2.0 sought to overcome the DoubleClick constraint so as to enable Google to expand its ability to serve account-based advertising to account holders and accordingly generate a lot more advertising revenue. Now, the expert evidence turned out to be pretty irrelevant in the case, and I think that was largely due to the fact that it didn't go to the issues that were relevant to the questions the judge had to consider. He was also quite critical of the ACCC's expert. He notes there at paragraph 166 that her evidence contained personal non-expert expectations of what the notification and the June 2016 privacy statement preferably should have said. So she's sort of saying it would have been better to express things in a particular way. But clearly that's not expert evidence. And he also noted that her analysis incorporated unproven and in some cases generalized simplifying assumptions, and these assumptions may or may not have been valid, but the underlying facts to establish those assumptions could not be known. And furthermore, he concluded that while the expert evidence did provide some background and some context, it strayed far from the case at hand. So the expert evidence departed from the allegations which the ACCC had made in its concise statement, and overall he found it to be of very limited assistance despite how much time was devoted to it during the hearing. And he does quote in paragraph 233 Professor List's short but cogent point that the ACCC's experts' hypotheses could not be accepted or rejected without subsequent testing by empirical analysis, a task that was not undertaken in the present case. There was no consumer evidence. So effectively, a lot of the hypotheses put forward by the ACCC's expert could not be proven because there was no consumer evidence proving that that's the way consumers read the notification and understood the changes to the privacy policy. So the judge concluded, and it's a fairly straightforward decision, he just accepted that the notification did explicitly inform account holders of the changes which were being made. He was also satisfied that account holders, acting reasonably in their own interests, would have understood that the changes meant that Google was going to be getting more information, and that new information would be generated through putting together personal information from its existing accounts with information from other sources. And so he concludes that based on all the findings that he's made, that Google did inform the account holders of each of the matters referred to in the ACCC's amended concise statements that the ACCC had alleged weren't made clear. So they made everything clear enough to reasonably inform consumers. And then he concludes that, and there's a typo in the judgment, unfortunately, it follows therefore that Google, which obviously should say ACCC, has not established its case based on the notification representations. The notifications were adequate in explaining all relevant issues to a reasonable consumer. The explicit consent representation was also dismissed by the judge, and the first point he makes is that it should not be looked, the privacy update should not be looked in isolation. You can't separate it from the other information such as a notification announcement. You have to look at it all together and then determine what information was being conveyed to consumers. And once you look at all of the relevant information together, you can see that explicit consent was obtained from consumers, that there was no hiding of relevant information from the relevant consumers prior to the changes being made. He also said that it's important to draw a distinction between a reduction in rights and a simple change in the privacy policy. So even if explicit consent had not been obtained, which he concluded explicit consent had been obtained from the consumers, the case most likely would have failed because he didn't believe there'd been a reduction in the rights of the consumers. He notes that the changes were to the text of the privacy policy and they were quite minor changes, and accordingly there wouldn't have been established a reduction in rights, simply a minor change in the rights or in the privacy policy. And he also notes that really the relationship between the notification and the privacy policy has to be acknowledged. So here what's happened is Google did effectively notify consumers of the proposed changes and did get explicit opt-in consent through the notification, and that the changes to the privacy update were no more than a reflection of the consent which had already been received. So to look at them as standalone issues was not appropriate. They were quite integrated and related to each other. One interesting comment that he made in paragraph 290, and I might read it: in any event, the evidence is that regardless of the consents obtained through the notification, Google has not combined double-click cookie information with account holders' personally identifiable information in their Google accounts. And it goes, to be clear, the evidence is that before that date, Google did not associate double-click cookie information, and this has remained and remains a position. So effectively, the ACCC is complaining that people weren't given explicit consent about the merging of double-click information with personal information held by Google, but it didn't happen. The information is still being kept separate. So it's hard to say that somebody was misled into believing a situation would occur when that situation did not occur. That was a bit puzzling for me at the end there, that obviously with the explicit consent in their pocket, Google can make those changes tomorrow, but the fact that the change hadn't occurred seemed a relevant consideration, particularly in relation to whether there's any actual detriment to consumers arising from this case. And just a bit of quick commentary about the case. It just appeared to me that the ACCC's arguments were very technical and really required a bit of creativity to understand how there was any detriment arising from the conduct engaged in. It seemed that consumers were reading the representations and coming to various conclusions, but there was no evidence from those consumers as to the way they read it. Rather, it was being relied on expert evidence and internal documents. And I think this is a case where you need to put consumers before the judge. And I think it's the second case the ACCC has lost before Yates, where they failed to put consumer evidence. The previous one was the Woolworths case, where they were seeking large amounts from suppliers a few years ago, and the case was dismissed by Yates. And when I was at the ACCC, I ran a couple of cases with Yates. He was my barrister, and it seemed to me from working with him as a barrister that he valued having real people in the witness box explaining how conduct had impacted them. And it seems to be a mistake of the ACCC to try and run cases in front of Justice Yates without putting real live witnesses in the witness box. And I think if they had done that in a particular case, the judge would have seen some detriment, and it would have supported the evidence put forward by their expert, which seemed to fall over because there was no empirical justification for the evidence. I think it's also important to show some detriment if you're running cases, and here it's very questionable there was detriment, particularly as Google hadn't put the two sources of information together from DoubleClick with the other information, the personal information. So again, the judge is questioning whether there's actually any consumer detriment arising from this conduct. The expert evidence proved to be of little relevance, and I think partly maybe the expert tried a bit too hard and went a bit beyond the brief and sought to convince the judge of various issues. And it's very important as an expert to stick to the brief and also to base any views on evidence, any assumptions on evidence which can be proven. And here there was obviously a disconnect between the hypothesis put forward and the empirical evidence to prove those assumptions. The prospects to appeal seem quite limited to me. I think the case is fairly straightforward. There's really no formed a negative view of the value of the experts, and really it's the judge's reading of the notification and other documents and forming the view that it was not misleading. So I don't think the ACCC's got much prospects of a successful appeal, and I would be surprised if they did appeal it, because I can't see them getting a better outcome on appeal. So I guess I just conclude that I think the ACCC sort of got a bit lost in Narnia in this case. They seem to be running a lot of different submissions in the trial, which were not consistent with what it had in its concise statement. Also, the experts seemed to move away from the evidence that was consistent with what was said in the concise statement. So it seems to be you're in a trial and things aren't going well, and you're sort of scrambling around to find some other arguments that might interest the judge. But ultimately, you can't succeed unless you prove the allegations set out in your concise statement. So it seemed to me that the trial went a bit haywire, and I think the ACCC got a bit lost. So if you have any questions about this presentation, feel free to give me a call or send me an email. Bye bye.